Oh. All right, we go with the technology side. Just a speaker that needed to be muted.
Yeah, I did that before I started. I don't know what happened.
Okay, no problem. I've only had that happen a few times. Okay. Good afternoon, everyone. It's 1:30 p.m. on December 10th, 2025. Call to order this public hearing. The Board of County Commissioners for three land use files, or three files. File AM003-25, file ZC0008-25, and file ZC0011-25. First on our agenda is file AM003-25, and with that, we start by asking if we have anybody who needs any assistance, hearing assistance, aids, or things of that nature. And then if we could please do conflicts of interest with the board.
Commissioner Corn has no conflicts.
Commissioner Williams has no conflicts.
Commissioner Domke has no conflict of interest. And then the public hearing procedures are that staff will present their report. The applicant will provide an opportunity to provide an overview of their project and answer any questions from the governing body. We will then move into public testimony. We'll start with those who are in support of the project, then any who are neutral, and then anyone opposed. We will then offer a rebuttal period for the applicant, and then after that, the public hearing will be closed and the board will move into its deliberations. So with that, we will turn it over to Mr. Britt for the staff report.
Thank you, Commissioners. Good afternoon. Daniel Britt, Planning Staff for the record. We're here to discuss AM0003-25. This is a request to go from ag forest land to rural residential. These are the following Bonner County revised codes for which this application was reviewed against, as found in the staff report. The following agencies all agencies were notified in taxing districts on June 10th, 2025. The following agencies provided comment: Bonner County Historical Society, Idaho Department of Environmental Quality, Idaho Department of Fish and Game, Idaho Transportation Department, Idaho Department of Water Resources, Idaho Transportation Department again, and Panhandle Health District. The following agencies replied with no comment, and that was Kootenai-Ponderay Sewer District and TC Energy. As the date of the staff report, public comments were received on this request. The applicant is requesting a comprehensive plan map amendment from ag forest land to rural residential. The purpose of the request is to support a concurrent zone change request. The proposal is approximately 10.72 acres. The property is located on the southeast corner of Highway 200 and Old Highway in Sandpoint in Section 3, Township 57 North, Range 1 West. This is on the left-hand side, the aerial imagery is a broader view of the area that we're talking about. The parcel, the lot we're discussing this afternoon is highlighted in red. The image on the right-hand side is outlined there in black, is the lot itself, which is Lot 2. So the current designation for this lot is ag forest land. Its designation recognizes where the ag forest land use designation recognizes areas where steeper slopes prevail, meaning 30% or greater, and transportation is provided by private roads or U.S. Forest Service or state roads. Urban services are not available, and residential development challenges are present due to slope, poor soil conditions, hazardous areas, and lack of police or fire services. Proposed designation is rural residential. The way the comp plan sees rural residential is the rural residential area provides for residential development in areas where urban services are not available and slopes may vary up to 30%. These areas include hazardous areas and critical wildlife habitats where lower density reduced potential for impacts to resources and exposure to loss of property or lives. Small-scale agricultural uses and residential developments are permitted. So a little background on this lot. It is platted. It's approximately 10.72 acres. The Current zoning is AF10 and the current land use designation is ag forest land. The property is accessed from Old Highway, which is highlighted green in this slide. So some environmental factors. The site does contain map slopes ranging from 0 to 30% or greater grade. The site does not contain map wetlands. The site does not contain map lakes or streams. The lot is within Special Flood Hazard Zone X per FERC panel number 16017C 0735E with an effective date of 11/18/2009. So the soil that is found on this lot is Ponderay rock outcropping complex with a 5 to 45% slope. It is complex, it's well drained. It is not prime farmland, it's classified. Services to this lot, water is to be served by an individual well according to plat instrument number 976551. So sewage disposal is supposed to be an individual septic system, same plat instrument number. It's within the Northside Fire District. Power is provided by Vista Utilities and is within Lake Ponderay School District number 84. So getting into the slopes a little bit further, the Bonner County proposed land use matrix criteria chart found the adopted land use component from December 20th, 2005 on page 22 in the slopes column. Ag forest land, slopes can be 30% or greater or equal to. For rural residential, slopes can be 0 to 30%. This parcel has map slopes of 0 to 30% or greater slopes. Approximately 4.27 acres of the map slopes is from 0 to 15%. Approximately 2.45 acres of the map slopes is 15 to 30%, and 2 acres of the map slopes is 30% or greater. Those numbers are approximations, so it doesn't add up to the 10.72. Those are just rough guess sketches. So the Bonner County proposed land use matrix criteria chart found in the adopted land use component from December 20th, 2005, page 22. Under the general transportation criteria states, ag forest land, number 3, public right-of-way, paved or gravel, private easements, international fire code standards that the roads are built to. Number 4 is U.S. Forest Service, Department of Land or private road systems adjoining county or state public transportation systems. For rural residential, note 3 says public right-of-ways, paved or gravel, private easements, and roads built to international fire code standards. The parcel is accessed via Highway 200 and Old Highway. Highway 200 is a state-owned and maintained paved right-of-way. Old Highway is a Bonner County-owned and maintained treated gravel right-of-way. This is that chart that I just mentioned in the previous slide, and the arrows outline the rural residential and the ag forest land, and below that are those notes as discussed, 3 and 4. This is looking at the lot. The green line there indicates that's a Bonner County owned and maintained road. The lot is highlighted in blue there. So next we look at critical wildlife. The proposal does not contain any mapped wildlife habitat. The currently adopted natural resources component from March 13, 2024 on page 21 quotes all of the endangered and threatened species of plants and animals as classified by the U.S. Fish and Wildlife Service. Bonner County is designated critical wildlife for bull trout only. Lake Ponderay is approximately 2 miles away from this proposal. This is looking at that map with the mapped critical wildlife. And the red arrow on the screen you can barely see is pointing to the lot in question this afternoon. So we'd look to see if we can support small-scale agricultural uses. So there is no mention of agricultural uses in the ag forest land designation. However, section 5.1, agricultural, page 11, land use, quote, recognizes that 10-acre minimums are too small for viable agricultural pursuits, with the exception of berry farms, hobby farms, or small horse breeding operations. This is a letter to the commission stated by Wood. Residential designation mentions the small-scale agricultural uses and residential developments are permitted. The Bonner County Revised Code allows for small-scale agricultural uses that are either permitted by right or require a conditional use permit in both the AF designation the AF zoning and rural zoning districts. Residential development, Chapter 6, page 18, proposed land use states, quote, Bonner County recognizes that it needs to encourage development in areas where services are located and to protect its productive timber and agricultural lands. Slopes also factor into the future land use analysis. Areas of steeper slopes, 30% or greater, are recognized as poor areas for residential development because of the need for excessive road building, exposure to wildland fire, erosion potentials, and challenges to adequately serving these areas with fire and emergency services. More than 40% of the woodland acreage is on steep erodible soils. This proposal has map slopes that vary from 0 to 30% or equal to or greater. Adjacent to the lot is Highway 200, an Idaho State owned and maintained paved right-of-way, and Old Highway, a Bonner County owned and maintained gravel right-of-way. This lot is within the jurisdiction of Northside Fire District, and law enforcement is the Bonner County Sheriff's Department. Plat for the subdivision requires that individuals provide their own water and sewage disposal. Planning Commission recommended denial of this request with a vote from 4 to 2. That concludes my presentation, so I can take any questions the commissioners may have.
Board have questions?
Can you go back to that slide where you mentioned the agricultural, and they were saying on page 11, when it said wood said, I got confused and then the slide moved. Is that quoting something out of our?
It's quoted out, sorry, let me find that, there we go. That's a direct quote from the comp plan on page 11. Whoever Wood is, it stated that when they did the comp plan in 2005 under the land use component.
Okay, but it said a letter to the commission stated, that's out of the page, is what you're saying. That it says a letter to the commission.
Correct. I'm not sure if
I wasn't sure what that meant because.
I don't know if the commission was the BOCC or if it was the planning commission, and I'm not sure who Wood was. If he was some type of expert in.
Okay, thank you.
Yes.
Take a 2-minute recess and see where we're at until 1:45.
Okay.
Thank you. Okay, it's 1:50. We're back from recess. Daniel, do you have the ability to pull up the land use component
I do. Give me a
for the
moment.
board to see, if you would, please? I see that it's on page 11 of the document. Since the document doesn't actually have normal page numbers, it's a little harder to find. Just so we can see it in context.
There we go. Zoom in on that a little bit.
Second paragraph from the bottom, it looks like. Commissioner Williams, this is the statement, if you would, from Mr. Or Mr. or Mrs. I don't know, somebody would, in context, is the,
I pulled up the agricultural
yeah.
document to see on that. Thank you.
That's Woods' opinion.
So, yeah, well, and it's even it's a reference to public comment, right? So it says, during workshops on the update of the comprehensive plan in 2005, members of the agricultural community met with the Planning and Zoning Commission and urged the county to take steps to preserve agricultural lands. Testimony from the public included concerns that the 10-acre minimums are too small for viable agricultural pursuits, with the exception of berry farms, hobby farms, or small horse breeding operations, a letter to the commission stated. And so that was public.
I'm not sure why that would be in our presentation for today. I don't know what the relevance is on that.
I wasn't either sure on that one, but I think in part, it was an argument for what the change request was. But I think in our document, it's clear there's a range of farming, agriculture, depending on what your size is, I guess.
Okay, but it's good to have the context, so thank you for pulling it up, Daniel.
You're welcome. And so just to address Commissioner Corn's, we go looking for something in the comp plan that discusses that, and because the ag forest land doesn't really discuss the definition doesn't discuss ag uses, what that looks like, so that's how that got quoted.
It's as if they assumed it was obvious, so they didn't even talk about it because it's an ag forest piece.
I think that in terms of the staff report, I think it's looking, for me, is it a fact that we're saying, like, what was the resource?
I just think we have newer, updated information regarding what we can do on 5 acres, and we can actually turn profits on certain things if we wanted to, agriculturally or whatever.
Right. However, the code says that we have to analyze these requests against land use components specifically, not the other components of the comp plan.
Thank you.
You're welcome.
Does the board have any other questions on this particular item?
I don't.
Nope.
Okay. Thank you.
Thank you for your patience of fielding an emergency, which is not timely.
So now that I've thrown you off, you can continue with the staff report.
He went.
No, I was done with my
Oh, you were done, that's
presentation.
right, we went
so-
back, I
Question.
apologize, I
We
got
did,
lost in that. Okay,
Yep.
thank
He
you.
was done, I asked a question and it ran out.
Does the board have any additional questions for staff regarding the report?
Nope.
Okay. And with that, we'll turn it over to the applicant or the applicant's representative, if we have them in the audience.
Hello, Commissioners.
You're welcome to
Luke
use the
Webster.
podium if
Oh,
you
yeah,
prefer.
yeah, that would actually be helpful. Daniel, could you bring up, like, just one of the larger map that kind of shows the piece of property with the old highway and Highway 200.
Absolutely. Look, we're already there. Okay.
Hello, Commissioners. Luke Webster, Bonner County resident. So the piece of property in question, I'll just kind of poke you. Here is going to be, this is Old Highway. This is where Highway 200 used to go around my property. So I own this property on the north side of 200 and the northwest side of, or the west side of Old Highway. This piece, the east side of Old Highway. I also own this piece, the south side of 200 and the southwest side or the west side of Sunnyside, and I own this piece that is the east side of Sunnyside and the south side. So it's kind of like, it's a bunch of parcels here. The highway didn't used to, it never went through this property, it went around it. This is a big finger, kind of the northernmost part of Sunnyside Peninsula, kind of the rocky part that comes out. These pieces down here, and I tried to explain this, I didn't do a very good job with the planning department, but the planning commission. These pieces all down here are 5 acres typically. The stuff that's always been to the north has been larger egg farmland. This piece has never been farmed. Everything around it to the north and kind of the northwest has been farmed. I owned these pieces previously, but I'd sold them. These pieces are, it's a rock, it's a pretty big rock, but my thoughts are I would like to split it and do 2 home sites there, just because it's not super conducive for farming. It is steep around this edge here, and then it's a plateau on top, and then it's flat down below. Anyhow, so one of the things they mentioned was, well, everything south of 200 is, kind of good for that 5 acre zone. North is Marcelli Valley, and it's an area where typically there's larger plots of land for farmers. My reasoning I was trying to explain is this was south of 200. It was part of this piece, which is 5 acres. It's a really interesting piece. There's 3 different zonings, right? It's right at that corner there. It's a section corner. So that's, I guess in terms of what I'm looking at doing there, that's what I was looking at doing there. But fast forward to, where we are now on the piece, it just didn't get a lot of good reception through the process. So my thoughts are I have some questions. When I look at the underlying zoning of the piece, a question I guess I would have for planning professionals or for the commissioners is, under Title 12, specifically 12-311 and 312, is it correct that the official zoning district map is the controlling legal document for land use that we hold to?
In this, you're giving your presentation to us.
Yeah. I have a question there, so I guess I need, in order to continue my presentation, I would have to know if that's the case or not.
So I'm going to offer that from my perspective for the board, because you've pursued an application, you made an assumption going into the application of what that is. You're requesting a comp plan map change with a subsequent zone change. So it appears to me that you've made an assumption that there's zoning that should be changed. So I'm not understanding. So I'm not seeking the answer to the question. I'm just giving a perspective that
Sure.
you have applications before us.
Yeah.
So
my
if you wanna
application is
make your
based
argument.
off that, is based off our Bonner County comprehensive or the underlying zoning map. But through my discovery and working through, kind of public records requests and trying to attain a legal copy of our map, I haven't been able to find an executed copy of them. I get a lot of copies like this one, Bonner County official zoning district map, but it's not signed. And it hasn't been signed by this is probably a problem that you guys inherited. It seems like I've gone back to 2022, nothing's been signed. Go back to 2008, no signed copies. So there's never, and going back in even farther, as I look into the history of Bonner County, this same thing happened in 1982 to Shaw versus Bonner County. The county attempted to enforce zoning without an adopted zoning map. The court held that without the valid zoning map, the county lacked legal authority to enforce zoning ordinances. So I believe that the county's out of compliance with zoning ordinances, and I think they have been out of compliance since 2008, when they created the previous copy of this map. Public records requests are showing none. I can't get any record of a duly executed and signed map. Nothing that's been, that follows 12-311 and 12-312. So my suggestion would be that, I don't think that you can rule on land use unless you have the authority underneath to do that. So for me, right now, it originally was about I'd like to get my public, I'd like to get this pushed through and approved, to have my rights to split the land, but I don't know what the underlying zoning is on my land because I haven't found a legal copy, and nobody in the county has been able to produce a legal copy of the Bonner County zoning map.
Can I ask you, are you asking to withdraw your application for the comprehensive?
No, I'm asking for the county to provide me with what is the current legal
But in
zoning.
this hearing, you're here before us to address
I'm here
the
to
change. So are you asking us, because I've heard you say you don't think we have the authority to make a change at all. So are you asking to get rid of both of these hearings?
No, I'm asking you to amend or approve an underlying zoning map.
That's not the purpose of this
That's not what we're
hearing.
here
So
for,
I'm,
though.
Well, I don't see how you can make a decision on a hearing when you don't have credibility to do so.
Okay, so are you asking us to discontinue this hearing under the guise that you don't feel we have credibility to move forward with this hearing?
I would say without a zoning map, I don't see how you can make rulings. So I would just say you'd probably what I would suggest would be table and then research and produce this map or figure out what, are we in compliance? I don't think it exists. I've been told, I've heard some crazy stuff I've heard that it was too big for them to take a legal copy or a copy to file with the recorder's office because it was a large map and they didn't have the scanning ability to produce it. And then during the process, somebody's lost it or it was stolen or it's been misplaced. But we have a recorded document number for what it should be, but it doesn't exist digitally and it doesn't exist physically at the county.
so Mr. Webster, if I could clarify, please. The file we have before us right now is a requested comprehensive plan map amendment.
Yep.
Comprehensive plan map designation informs zoning.
Correct.
So would you like us to proceed with the hearing for the comprehensive plan map amendment request that you've made to come to a decision? Or are you asking us to
I don't know if you can.
continue the hearing or making some other request? I'm trying to understand
I would say table
what you're
until you have
asking.
legal, probably some sort of understanding if you can make those decisions based off of Title 12 tells me that you can't unless that exists. And maybe it does exist. I can't get a copy of it.
So based on what I'm hearing, the applicant who's brought this forward, because we have a map amendment with a subsequent zone change, he is saying that he doesn't feel the board has authority to address the issue that he has brought forward. And so it sounds like he's asking us to remove the two items from this agenda, and that doesn't require us to take a vote. It's if he wants us to make a decision, we would move forward with a decision. He's not asking us to make a decision, so it's my position that we move to the third file that's not, because he's got the first two, and then we have Smith's Rule 10 to Rule 5. Because by his statement, he is saying, I don't think you can make a decision, but we're only here to make a decision. We are not here to challenge the issue that he's bringing forward as to whether or not we can make a decision. So instead of, I hear what he's saying, but his argument is essentially he doesn't want us to make a decision.
And that's what I'd like to clearly understand from the applicant, because what I'm hearing is the questioning of whether or not there's an official zoning map in place to make a decision on. The file we're hearing right now is the comprehensive plan map, which is not the zoning map. And we're being asked to make a comprehensive plan map amendment. So the subsequent zone change requests I can see being relevant to the conversation about the official zoning map, but with the current file in front of us, I don't see the relevance. And so I would just like to know from the applicant, if you're asking us to not continue the hearing, that you're seeking some other course of
I would just
action.
like for you to table till I can get a legal copy of what the current true underlying zoning is.
Okay, so then both of the files that you have before us as the applicant, you're requesting the board to table, which my interpretation of that would mean continuing or not, well, it would be continuing the hearing to a date certain.
Yeah.
Per.
Please.
But we don't have to continue for him to a date certain. He can just bring forward his same request back to planning department. What's the reason he can't do?
Once we've started the hearing, I'm not sure.
Well, if he's the one that's withdrawing this is the hearing. He's pulling his issue off the table. We don't have to agree to
I think
anything.
I think I would
So,
disagree with that.
Daniel Britt, planning staff. Commissioner's correct, Domke, that we're here just hearing the map amendment. The question of zoning may be an appropriate one for the next file. However, this is for the map amendment. There is a signed copy of the comp plan map. If you'd like a copy of that, we can provide that in 30 seconds or so. So
No,
not a
he's
problem.
asking for us
I
to
understand what
table.
he's asking for, but the
Right.
file that we're discussing only is the
Yeah.
map amendment.
I'm trying to separate the
Not
two
the-
issues and determine.
Correct.
I can just wait till the next one and then do
But
it then.
he was,
I just,
on this file, he said table this file.
Can we get Nate? You know,
Yeah.
did you confirm if he'd be available?
I did not.
Okay.
I did not do that. But I can give him a call.
That'd be great if we can get him. The legal question I have is procedural, that because we actually began the hearing, can we simply end the hearing and the applicant still has the ability to get it rescheduled and come back for the same application? Or do we need to continue the hearing, or do we need to make a decision?
In the interest of
Because we
saving
started the
time, you
hearing.
could just say, continue to a date certain, and then it addresses it. I'm just saying you don't have to do that. So we could get out of this issue, and I would concede, because to me, it's the same thing. So it's just, you don't have to. So we could say, continue to a date certain if he wants 60 days. I would recommend that you go past the month of
December.
January, because the board, every week, the board has something. It's the first start of legislative session. So I would give them a date in the month of February, which would give enough time, and then you don't have to worry about the legal thing. I'm just saying, you could just say, just bring it back when you wanted to, when you were ready after you got the information. If we don't want to do that, date certain accomplishes your concern, his concern, and mine to go forward.
I'd like
Does
to
that work?
continue
Yeah, I
to a
think that
date
works.
certain, just to be sure that procedurally.
Sure.
We had
I didn't mean
a misstep.
to mix them together either. But I figured just do it
Just
all.
from my perspective, they're
Can you look
distinctly
at your
different, but I'd
February?
like to,
Can you look at your February calendar?
February 5, February 9.
So February, what does the board,
Or there's things on the calendar.
so February 5,
I can check what we have scheduled.
don't see any particular files yet assigned to that date, but my
There's a
calendar may not
hearing.
be. Yeah, they block out dates, but
Okay,
then
so
we don't
there's
have
nothing
files
set
assigned
in
yet
there.
necessarily, but their calendar is more current than ours when it comes to file scheduling. So the 5th would be the soonest.
I don't have anything scheduled on that date.
So-
On either of those
Okay.
dates.
Is that timing?
can you do 5?
Yeah, that'll be fine.
And the time that this is blocked out is 10 a.m. to 12 p.m.
Okay.
Will that work
Yeah,
for
that's
you?
totally fine. Easy.
You're actually on my list for a different reason.
Probably a lot of reasons.
Positive one for me,
Good. All right, well, that's all I
So
have.
but,
we'll,
no, you gotta,
yeah, so then we will, at the request of the applicant, we'll entertain a motion to continue this hearing.
I'll make a motion that we continue this hearing on file ZC 0008-25 and ZC 0011-25. Can we do both of them?
no.
Just the one we're.
You have to, so I
Alright.
won't second you. You have to do the first file, we vote on it, and then we actually have to open the second file
Do it
and vote
again.
on it.
All right, so I didn't make a motion because I was just talking to myself. So I'll go ahead and make the motion that we continue file number ZC 000.
Commissioner Corn, you have to do AM. We have not opened ZC.
I thought we were on AM.
We are on
Pull my
AM.
tab out.
Yeah, we're going to do AM first.
Yeah, you ready?
Their turn.
That's what they say. I make a motion that we move AM 0003-25 to February 5th at 10 a.m. at the applicant's request. 2026.
I second the motion.
Okay, do we have any deliberation on this?
Nope.
Roll call vote, please.
Commissioner Williams,
Yes.
Commissioner Donkey,
Yes.
Commissioner Corn,
Yes.
Motion passes. We will now open the hearing for file ZC 0008-25. Call for any conflicts of interest.
Commissioner Williams has no conflict.
Commissioner Corn has no conflict.
Commissioner Domke has no conflict of interest. And with that, in lieu of starting with the staff presentation, since we have a request of the applicant to continue the hearing
Can
to,
I pause you? We have to treat it like we didn't hear that in the start of this.
So we have to
where it's
open the
on.
hearing.
So you don't have to go through that. He has to verbally state it in this hearing. Mr. Webster has to say that.
I'm fine with that, but I want to confirm just procedurally. I thought we've had applicants come in before we started hearings and they've asked us to continue and we just immediately went to continuation.
We are, but I'm saying he has to say it on the record for the hearing.
I was just saying we've had instances where that doesn't occur. Staff has been informed ahead of time, but since he's here, we can do it just to be as complete as possible. So if our applicant, Mr. Webster, is willing to state his request to the board, that would be appreciated.
Hello, Commissioners. Luke Webster. I was hoping to push this off until, I think it was January 5th, 2026, or February 5th, 2026, when the other ZC would be heard. And that'll give us time for me to kind of find out what the underlying zoning is.
thank you. Does the board have any questions for the applicant?
I don't.
Would you like to make a motion?
At this time, I move to continue file ZC 008-25 zone change agricultural forestry 10 to rural 5 to a date certain of February 5th, 2026 at 10 a.m.
Just to confirm, we said 3 zeros in there.
Not certain.
I would confirm, I would second that for ZC 0008-25.
Okay, do we have any board deliberation?
I don't have any.
Roll call vote, please.
Commissioner Williams,
Yes,
Commissioner Donkey,
Yes.
Commissioner Corn,
Yes.
All right, motion passes.
thank you.
File has been continued. Now on to file ZC 0011-25. Commissioner Williams, do you need a few minutes? I'm not sure, so it's great. We got it confirmed, so we should be good. Okay. Call for any conflicts of interest?
I don't have share access at the moment.
Commissioner Domke has no conflict of interest?
Commissioner Corn has no conflicts of interest.
Commissioner Williams has no conflicts.
And then once staff is up and running, we will turn it over to them for their report.
Good to go, Commissioner.
Please proceed.
Kyle Snyder, Bonner County Planning Staff for the record. I'll be presenting to you today ZC 0011-25, which is a zone request, or zone change request from rural 10 to rural 5. So again, the applicant's requesting a zone change from rural 10 to rural 5 on a 10-acre parcel. Project is located off Lazy Spade Lane in Section 18 Township 54 North, Range 2 West of the Boise Meridian. The comprehensive plan designation is rural residential 5 to 10 acres. And the request was evaluated against the standards for rural 10 and rural 5. There's the sections of Bonner County Revised Code that this project was reviewed against. Some quick background on the subject parcel. It is currently undeveloped and unplatted. Size is approximately 10 acres. Currently, it is zoned rural 10 as shown in that top image there. Land use designation again is rural residential 5 to 10 acres, and access from that Lazy Spade Lane, which is a privately owned and maintained easement. Some environmental factors on the property. It does contain mapped slopes of 0 to 30%, as you can see in that GIS image to the right. And the greater breakdown of that slope is shown below that image. The site does not contain any mapped wetlands, does not contain frontage on any mapped body of water, and is within Special Flood Hazard Zone X per the firm panel shown. As far as your services, it's your individual wells and individual septic. It is within Sagal Fire District's. Power is provided by Northern Lights and Lake Pend Oreille School District number 84. The full list of agencies is in the in the staff report in Appendix A. Comments were provided by IDWR, and the following agencies replied no comment, and that's TC Energy, Kootenai Pend Oreille Sewer District, DEQ, and Idaho Department of Fish and Game. And as of the date of the staff report, the Planning Department has received public comments. So these are your standards for a rural 10 parcel. So rural 10 in areas designated as rural residential in the comp plan that meet one or more of the following criteria. A, characterized by slopes that are steeper than 30%. B, located within critical wildlife habitat as identified by federal, state, or local agencies. C, contain prime agricultural soils. D, served by a network of public and or private roadways that generally do not meet applicable roadway standards set forth in Title II, which is our public roads of this code, or Appendix A, which is your private road standards of this title, or are absent. E, within the floodway, and F, contain limited access to public services. For your rural 5 zone, in areas designated a rural residential in the comp plan that are already developed at or near the 1 dwelling unit per 5 acres density, and or do not meet the criteria for R10. There's a quick side-by-side comparison of those standards. Getting into the rural 10, it's characterized by slopes steeper than 30%. Subject lot does not appear to be characterized by slopes steeper than 30%. As you can see in the GIS image to the right, the only slopes steeper than 30% are located in the southeastern corner of the subject parcel. According to the land use portion of the comprehensive plan for density ranges, properties that are level to moderately sloped are appropriately sized to be 5 to 10 acres. Or is located.
Sorry, Kyle, before you continue,
Yes.
could you, I'm realizing through other workshops and meetings that we're having that sometimes color differentiation of these maps can be very difficult to read. So could you please confirm if in the lower right or the southeast corner of the blue square, is it only those darkest shaded areas that are
Yes.
the greater than 30% slope?
Correct. According to that, the GIS greater breakdown, it's kind of this color you see here
Thank you for pointing
is
that
that main
out.
point, and then there's a few sprinkles through here.
As compared to the greater area of red.
I wish they would have made the red being greater than 30%, so it's easier to differentiate. Yes.
Thank you. I've come, like I said, I've come to realize at times we think everyone's following us when we look at these color maps, but they're not always perceived the same way because some people see color differently, and we don't have a lot of differentiation with the color.
Where's Chad?
Yeah,
That would
it's
be helpful.
and I understand they're trying to show like gradient intensity, like darker red's more intense than lighter red, but it's actually hard for people to read, I'm finding. So I just want to make sure we're all seeing the same information.
Yeah.
Thank you. Sorry for the interruption.
So no critical wildlife area was determined by any public agency. Additionally, the GIS data does not show the property within any critical wildlife habitat area. Contains prime agricultural soils. So the parcel contains two types of soils. You have Dufort silt loam, 5 to 45% slopes, and treble rock outcrop association, 20 to 65% slopes. According to the natural resources component of the Bonner County Comprehensive Plan, all other soil types not classified as prime farmland or farmland of statewide importance are classified as not prime farmland. There's those two soil types in the image to the right with their respective GIS data showing that they are not labeled as prime farmland.
So just so I'm clear, neither one of those colors are prime farmland
Correct.
soils. Thank you.
Served by a network of public or private roadways that generally do not meet applicable roadway standards. So access to the site is currently provided by Lazy Spade Lane, which is a privately owned and privately maintained easement. That connects onto Granite Springs Road, which is also a privately owned and maintained easement, with further connection to Sunset Road, which is Bonner County owned and maintained public right-of-way. Within the floodway, the subject parcel is not located within a mapped floodway, per the firm panel shown. As far as the public services, the subject parcel does have access to public services to include Sagal Fire District, Bonner County EMS and Sheriff, and Northern Lights.
So before you move on, when it comes to Lazy Spade Lane and Granite Springs Road, do we have any data as to whether or not the conditions of those private roads meet the applicable roadway standards?
That we do not. I think it's hard for us to to gather some of that data of exactly how those roads were constructed.
Thank you.
For your rural 5, you have developed at or near the one dwelling unit per 5 acres. Within 1,200 feet of the subject property, there are 16 individual parcels or lots, as you can see in that GIS image to the right. It appears approximately 6 of the properties in this area are developed at or near the one dwelling unit per 5 acres. The closest rural 5 zoning district does border the subject property to the south. And then you have and or does not meet the criteria for R10. So the subject property does not appear to be characterized by slopes of 30% or greater. It does not have any identified critical wildlife habitat. It is not within a mapped floodway, does have access to public services, and is served by a network of public and private roads. Additionally, there are no prime farmland soils located on the subject property. Zoning Commission recommendation was approved. That was done on October 23rd, 2025, a 3-to-1 vote. Any questions for me?
Or have any additional questions?
I don't think so.
Thank you. Okay, and we will now have the applicant's presentation.
Well, thank you all for your time.
You're welcome.
And really for doing what probably is more times than not a pretty thankless job. My name is Jeff Smith. My wife and I own the subject property. We also own the property that is directly south of it, and that's where our home sits. The idea behind when we purchased this 10 acres was to give us an opportunity to collect our family, so to speak. So we want to split this and have the opportunity to sell the northernmost piece of it to my daughter and son-in-law. Really part of that is we have a handicapped grandson that we'd like to be there for and help as much as possible. So if we have the ability to split off that 5 for them and then build a home there, that's what we're trying to achieve. The second 5, where the little bit of greater slope is, one of two things would happen. I have a son that may have an interest at some point in the future, but then if he chooses not to do that, we'd like to absorb it into the 5 we currently own, making our parcel a 10. And if you look at that map closely, there's kind of an odd 7 shape there to the neighbor's property, the Squire's property. And we have talked with them, and they are willing to do a boundary line adjustment at some point to make their current easement to their property, which is on my property, have them own that and eliminate that kind of small sliver that's between the subject property and my current property. So that's basically what we're attempting to do.
Can I ask you,
Of course.
because yours is a little bit more straightforward, but then when you added in the last part of what your ultimate desire is, it makes me
Yeah.
wonder, are we helping him achieve the best? Because if you don't end up selling it to a person that's not a family member and you're wanting to absorb it, is this the best way to try to achieve what his overall potential outcome is what I would like staff to, because what he's saying is if he divides it and someone doesn't want the second one, he wants to add the 5 into his 10, mostly probably to not have multiple taxing lots. Is this the best way of achieving what his ultimate outcome is, knowing that he probably doesn't know the concrete answer of the other? Because he would just be coming back to absorb it in and potentially doing a boundary line adjustment of a different piece.
Well, I think the ultimate goal, this is Alex Fan, interim planning director. From what I understand, the ultimate goal is to create 5-acre parcels. And there's no way to make a 5-acre parcel without the zoning to be 5 acres unless there's a parcel that's already 5 acres and you can adjust the boundaries, but it doesn't seem like that's the case here.
Is the one that you own outright 5? Because he said, you said it would make his 10 though. So we would change.
To make his 10.
Yeah, so is it really that's what he's looking for versus a family split of what he has? Because if he makes this 10 into 2 5s, and then the other kid doesn't want the 5, he wants to absorb the 5 back into his 10, but you're in the same region. So is this the best way to achieve giving the opportunity for him to sell part of his property to one of his kids? Because, do you understand what I'm saying? Because he's potentially going to turn the 5 he has into 10, right next to the.
Potentially, but it sounds like the plan A would be to create 2 5-acre parcels, and the only way to do that would be through a zone change.
I know what Commissioner Williams is trying to say. I think what she's trying to say, what I'm hearing is that maybe it'd be easier to do a lot line adjustment and take the lower 5 right now and make that a 10 and make the 5-acre parcel be on the north side.
Because he's not
understand the
necessarily,
question.
well, because what he's really trying to do is give way to one of his kids to have a piece of the land.
Sure.
But they don't know the final outcome of the total acreage, which will be, if we change this to 2 5s, then he likely will come back for a zone change issue for the part that he has that's 5 that he wants to go back into the 10. And so is this the best way of achieving it? And does she have to own it, or can she build on it without owning it outright for you?
Well, so Commissioner, she has to own it because they have to borrow money.
Okay, I see.
And so that needs to be done.
That's your linchpin on it.
And the ultimate goal is not for me to necessarily absorb the other 5 and have the 10. That's kind of the secondary
That's your
thing.
backup plan.
That's the backup. The ultimate goal is to have both my son and my daughter on 5-acre parcels right next to me.
Okay. I just wanted to
No,
see
I
if there
think
was
that's
a
a
different
wonderful,
option.
great
than the
question. If
10.
there was a better way to do that, if that were my strict goal, I'd say, I'm
It's
sure
just
open to hearing it.
Because you'll come back if that's the case to
Yeah.
say, I don't want 2 5s because I don't want to have 2 different taxing lots.
Mhm.
So, okay, I was just thinking of.
Yeah,
why
I
do we want
appreciate
3
that.
taxing lots?
Yeah, if there's a cheaper way to do it, I'm all in.
No, because I understood what you were asking from the onset, but when you said you would probably absorb that 5,
Mhm.
then I was like, well, why would we do this?
Uh-huh.
Okay. I hear you, thank you.
Any additional questions at all?
I don't have any.
Okay. I think you probably saw or had the opportunity to. I did kind of poll all my neighbors, and of the 6 of them that are pretty much contiguous, they signed and wrote letters in support of what it is we're trying to do.
I don't have any questions.
Any additional presentation for us?
Nope, I think that's it.
All right, thank you. We're going to go to public comment. Do we have anyone? We don't have anyone in the room other than the board, staff, and applicant. So I'm just going to go to online and see if anyone online has any public comment in support of this application. Does anyone online have any neutral comment to this application? And does anyone online have any opposition to this application? Can I see everyone that's online? Yes, it's the same group. Okay. Did anybody see any hands go up? I did not.
Okay,
If
with
that
that,
yellow bar is not up there, so you're good.
we will close public comment. We'll go back to the applicant if they'd like to offer any rebuttal to our lack of comment.
I can't comment on anything that was said.
If there's anything else you'd like to say.
No, thank you.
Okay, thank you. Okay, then the public comment period is closed and we will move into board deliberation. I'm going to suggest for efficiency that we move directly into the use of our worksheet. Unless another commissioner has an opposing opinion.
No, I'm fine with that.
Okay.
We're gonna skip 6511 typically.
Yeah, 6511 for this particular. I'm gonna come back to the comp plan, go through the code first. So we'll start with BCRC 12-215, whether the application, the documentation provided by the applicant sufficiently meets the applicant contents criteria.
I find that the application meets the requirements and adopt the analysis found in the staff report.
I do as well.
I concur. 12-216, whether there's adequate evidence that the proposal is not in conflict with the policies of the comprehensive plan as found in the adopted implementation component.
I found that there was no conflict since they're both in the rural area of the comp plan.
I agree, and I feel, and I adopt the findings in the staff report on that as well.
Okay, I concur with my fellow commissioners. BCRC 12-323B1, whether the parcel in question meets the requirements for the rural 10 zoning district.
I said no, that I think that the red or pink or whatever color that blends itself together is not significant enough on that particular parcel for me to say it's characterized by slopes. I think it does contain some not slopes. There's also the network of public-private roads, and I believe that the staff report said no prime ag soils.
I would agree that I'm a no on that one.
I also agree. I know I've always taken a slightly different position on how I interpret characterized by steep slopes. To me, it has to do specifically with the rest of the language in that code section that talks about reducing development impacts and costs. And because of where the access comes from, I don't see where that limited amount of steep slopes would impede normal construction methodology and access. So it shouldn't have unnecessary environmental impacts or construction cost impacts. So for a slightly different reason, I concur. Yeah, I concur with the other findings of the commissioners. And I also adopt the findings of the staff report for this item, in addition to the commissioners' comments. And then BCRC 12-323B2, whether the parcel in question meets the requirements for the R5 zoning district.
I believe it does.
I said I believe it does, and I adopted the staff report with respect to the comparison between the 10 versus 5, and found that it does meet the 5 zoning district.
I concur. I believe it does not meet the criteria for R10, and I believe it does meet the at or near the 1 dwelling unit per 5 acres. Just given there are both larger parcels and parcels at the 5 acre size, but given the contiguous nature with 5 acre parcels, I also want to take into consideration the public comment of the affected neighbors. So I think it was helpful to have that public comment. And I
believe Commissioner Williams, you said you adopted the findings of the staff.
I did.
Okay, thank you. Then going back to the top, Idaho Code 67-6511. I'm not going to read that all, but we have to analyze the proposals ultimately to determine whether or not it's in conflict with the policies of the adopted comprehensive plan.
I found that it was not in conflict with the comprehensive plan.
I agree, and I adopt the findings of fact in the staff report.
I also agree and find that it was, as was stated with reference to the same topic within the Bonner County Code, that the difference between R10 and R5, there is no difference from a comprehensive plan perspective. It meets all the same goals and policies when it comes to rural residential development and uses, and agricultural uses, so I find those to be consistent for both zoning designations. Excuse me, zoning districts under the rural residential designation.
I agree.
So per our worksheet, we have as a board unanimously agreed that IC 676511 is a yes. We do not have any conflict with the policies of the comp plan. BCRC 12-215, yes, that it meets the application content criteria. BCRC 12-216, if there's adequate evidence that, again, we're not in conflict with the policies of the comprehensive plan, so that was a yes. We are not in conflict. BCRC 12-323B1, whether the parcel in question meets the requirements of the rural 10 zoning district, and we said no, it does not meet those requirements. And BCRC 12-323B2, I heard yes, that it does meet the requirements for the rural 5 zoning district. Have I misspoken in any way based on my fellow commissioners' opinions?
Yeah.
I don't believe so.
Okay, then with that, entertain a motion.
I move to approve this project file number ZC 0011-25, requesting a zone change from rural 10 to rural 5, finding that it is not in conflict with the policies of the Bonner County Comprehensive Plan and Bonner County Revised Code as enumerated in the following conclusions of law. Conclusion 1, the proposal is not in conflict with the policies of the Bonner County Comp Plan. Conclusion 2, this proposal was reviewed for compliance with Title 12, Bonner County Revised Code, and was found to be in compliance. Conclusion number 3, the proposal is in accord with the purpose of the Rural 5 zoning district provided at Chapter 3, Title 12, Bonner County Revised Code. This decision is based upon the evidence submitted up to the time the staff report was prepared and testimony received at this hearing. I further move to adopt the reasoned statement as discussed in deliberation at this hearing and the analysis as set forth in the staff report or as amended during this hearing, and direct planning staff to draft the reasoned statement to reflect this motion as set forth in Idaho Code Section 67-6535. Have the chair sign and transmit to all interested parties. This action does not result in the taking of private property.
I second the motion.
Any board deliberation?
I have none.
I just hope we don't have to go back to, because I think you might box in. I just can't get that out of my mind, is if we say it does it, because you're very close to the other side. And so maybe, but if you want it, you get it, I guess.
You're getting it.
I don't want it to be wrong.
I think, I understand your good intent, and I do think actually this is, we've said it's compliant, and it actually gives the landowner the most flexibility with how they want to proceed.
No, I know, I agree going this direction. I'm saying if we kind of go backwards, that's what I mean. If you find in the end that you wanted to go backwards. That was my worry. I think it is the right decision, and it does give you the best flexibility to get, especially to the goal you want. That was only in the back of my mind.
No, I appreciate your thoughts.
Yeah.
But again, the goal is to have, separate.
Make your son watch it and say, you have to move.
Yeah.
You can't go backwards then.
Yeah, they're gonna make me move sooner or later.
Any additional deliberation?
No.
Okay, roll call vote, please.
Commissioner Warren,
Yes.
Commissioner Donkey,
Yes.
Commissioner Williams,
Yes.
Motion passes. Entertain a zone change ordinance.
I move to approve the ordinance of Bonner County, Idaho, the number to be assigned, citing its authority and providing for the amendment of the official zoning map of Bonner County by the classification of lands located in Section 18, Township 54 North, Range 2 West, Boise Meridian, Bonner County, Idaho, to Rural 5, and providing an effective date.
I second the motion.
Any board deliberation?
I have none.
None.
Roll call vote, please.
Commissioner Donkey,
Yes.
Commissioner Williams,
Yes.
Commissioner Warren,
Yes.
Motion passes. It is 2:41 PM, and this hearing